Good morning.
Good morning. Today's September 14th. Welcome to the First District Court of Appeals. This morning we have 4 cases that are scheduled for argument. The first case is In Re AJ, case number C210111. Attorneys, if you can please identify yourselves and your readiness to proceed.
Jessica Moss for the appellant AJ. I'm ready to proceed.
Keith Sauter for the appellee, Your Honor, so I'm ready to proceed as well.
Good morning to both of you. Attorney Moss, would you like to reserve time?
Yes, I'd like to reserve 3 minutes.
Okay, whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Jessica Moss and I represent the appellant AJ in this matter. This case concerns whether a juvenile record which were dismissed without prejudice are able to be sealed and then ultimately expunged. Now, our argument is twofold. First, it is that 21-51-356 B1D does provide for the immediate sealing of juvenile records after dismissal. But even if B1D does not specifically provide for sealing, then looking at a liberal reading of the statute combined with the legislator's intent for juvenile sealing ultimately will lead to the same result for the juvenile records to be able to be sealed. Now, as an initial matter, even if there is no ambiguity, there must be a liberal reading of the statute. Now, this statute for juvenile sealing was intended to give juveniles a greater ability to have their records sealed and expunged than that's available for adults. Specifically, only 3 charges are exempt from being able to be sealed and expunged for juveniles. Now, part of this goes along with the purposes of juvenile court to lead to rehabilitation and additionally to leave juvenile youthful offenses in the past.
Well, Ms. Moss, I'm sympathetic to your policy arguments for the reasons you've articulated, but I guess as I'm looking at the statute, it says, fines the person not to be a delinquent child, and I'm having trouble squaring that language fined with the dismissal that occurred in this case.
Yes, Your Honor. And essentially, so, on one hand, this part of the statute does talk about a dismissal after trial on the merits, but also finds a child not to be delinquent. And I can't think of any circumstance where you're not having a trial where the court's going to make a specific finding that the juvenile is not delinquent. So whether you have a competency issue, whether you have a juvenile Rule 9 dismissal of being in the best interest of the child and the community, whether you have dismissal, whether it's with or without prejudice, all of those, there's not going to be a specific finding. And the fact that there isn't an adjudication would only lead to the conclusion that there hasn't been a finding of delinquency. And in looking at 2152.02e as to what the definition of a delinquent child, that's only if the child violates the law. And so until there's been some finding, whether it's through the juvenile admitting or after a trial that the juvenile has violated the law and is therefore delinquent, that could only mean that there would be a finding that the juvenile is not delinquent by a dismissal. Additionally, it puts the child in the place that they would be in before the charges were filed, which would be not being found delinquent. And in AJ's case specifically, she has never been found to be a delinquent child. So, and it can only be said that she has been found not to be delinquent. Now, again, as the plain language, the case of In Re NK is telling because there specifically, we have a court after a dismissal, and although that was a dismissal with prejudice, that doesn't change the analysis here, is that the court immediately on their own ordered sealing of this dismissed charge. And it was only through some other circumstances that this got up to the appellate court in the 9th District. Now, the reason I think we don't see a lot of these cases is because I think a lot of juvenile courts are doing this and automatically doing that. In looking at 21-51-356, it's clear that the subsection C only talks about situations where a juvenile has actually been adjudicated when we look at whether or not the juvenile has been rehabilitated. Whereas the subsections under B look at other, whether it's a diversion, whether it's some other kind of a dismissal or finding of not delinquent, where there hasn't been adjudication. Now, even if 2151-356 isn't clear, then that's where, again, looking at what the legislator's intent was. Now, for adults, they could have their records sealed after dismissal without waiting any kind of period. And so if the legislator intended that juveniles should have a greater ability to have their records sealed, then it wouldn't make sense to then make this where adults could have their records sealed, but juveniles, when there's a dismissal, wouldn't. Additionally, there's no, for adults, there's no need to look at, while they have to look at statute of limitations, there's no specific provision in the juvenile sealing expungement statutes that look at a statute of limitations. And for adults, it's only about DNA testing and those results, not about the actual charges. Here, not only would AJ be able to have her record sealed if she was an adult, but there are several other cases that look at other extra judicial authority that the juvenile courts have to seal records when it's not specifically provided for in the statute. And here we have a situation where if this court does not find that the plain language of 2151-356B1D clearly allows for sealing, or without giving some extrajudicial authority or inherent authority, then these juveniles who have their records dismissed have no other way to have these records sealed.
So under your Pepper Pike analysis, what would the limit be on our ability to engage in extra statutory sealing?
So while in Pepper Pike, they do look at this other balancing test, which was then incorporated into the adult statutes. That was never put into the juvenile statutes. Certainly you could look at that, but primarily it's whether or not there is some other remedy for a juvenile to have their record sealed. And if this isn't available, then there's absolutely no way for a juvenile to ever have their records sealed and then ultimately expunged. So if the state isn't able to prove their case, if a variety of other situations where, again, that would stay on their juvenile records, whereas if they would have been adjudicated of not only in this case a charge of domestic violence, but a much more serious charge, the juvenile would have their ability to have those records sealed. And in looking back at what the legislator's intent was, again, to leave juvenile youthful offenses in the past and to make sure juveniles have been rehabilitated. Now, here, we certainly could look at that, but our argument would be that that's not necessary for the analysis since there's not been an adjudication. But again, if there wasn't enough to go forward with the case, it certainly should be that this juvenile should be able to move forward without having this hanging on her juvenile record without the ability to have that taken off at any point later, whether it's now or in the future. At this point, if there's no other questions, then I will reserve the remainder of my time. Thank you.
It's reserved. Good morning, Attorney Souter.
Good morning, Your Honor. If it may it please the court, I don't have a lot to add to what I put in my brief. I think that the question is, it's fundamentally a question of statutory construction here, and I just don't think there's any way that we can square what happened in this case with the plain language of the statute in which it.
Well, and I understand that argument. I guess I'm struggling with the issue of. If we want to give juveniles a fresh start, and in this case, there's been no adjudication of delinquency. In fact, the case has been dismissed. How, that seems to put a juvenile in a very difficult situation, particularly if someone just brought a complete bogus case and then disappeared, and you say, well, we're dismissing the charges, but now they're saddled with this on their record.
Yeah, Your Honor, I understand the contradictions in this case and the conundrum that we're faced with. My only contention would be that it's just not something that can be solved judicially. The exceptions that are set forth in the Pepper Pike case and the MBN case just don't apply here. I think if there were a case, one you just posited, where there were completely fabricated allegations, or some sort of using the juvenile justice system to gain leverage in some way or something like that, as happened in Pepper Pike, then I think we might reach the point where there would be the extra statutory authority to seal the record. But that's really not what happened in this case. As I note in my brief, this is the kind of a garden variety thing where the police are called in to solve a domestic dispute, and then once calmer heads prevail, the complaining witness simply doesn't want to go forward with any charges.
But I guess what's the state's interest in not having this sealed?
Well, I mean, first of all, I guess there's the maxim that sealing or expungement of records is an act of legislative grace, and that there's no right to that sort of thing. But I would say that in this case, there's been there are allegations set forth in the complaint indicating that this child caused fairly serious harm to her mother, punching her and pushing her down. And I think that the state does have an interest in maintaining that as a part of the record in case there are future incidents involving this juvenile. It would be the same as even though there wasn't a finding of delinquency in this case, there definitely was not a finding that there was no delinquency. So I think that's the state's interest in preserving the record of the allegation.
Attorney Souter, one of the arguments this morning is that the dismissal without prejudice is in fact a finding of that there was no delinquency, not to be delinquent. Can you respond to that argument?
Yeah, I think that's why the statute makes a distinction between the expungement statute makes a distinction between the situation in which there's a trial on the merits and there's a finding of no and a dismissal on the merits, and in the case where the juvenile magistrate or the juvenile judge looks at the situation and says, I know there are these allegations and we haven't gone to a trial, but based upon what I've heard, I find that the child was not delinquent in this situation. And I just don't think that either of those situations is applicable here. There hasn't been any finding at all on the merits. There was just a brief hearing in which it's not on the record, but it's apparent from the record that what happened was the mother came in and said, I don't want to pursue these charges. So
how could there be a finding that a child is not delinquent before it goes to trial?
Well, that's the distinction the statute makes, Your Honor. And I can't think of every permutation, but I can think of I can see where it could happen that the situation like this, where the complaining witness comes in and says, look, this was completely blown out of proportion. She wasn't delinquent. Please make a finding on the record, or the complaining witness or the defense attorney could say, I would like a finding on the record that she was not delinquent in this case because it could affect her juvenile record. But that is not what happened in this case.
Well, I guess that's my question I was getting ready to ask, which is, if you're a juvenile in these circumstances, should you resist the dismissal and insist on an adjudication so that you have the right to have the record sealed?
Well, the adjudication wouldn't necessarily. It's not just an adjudication that would give rise to the right to have the record sealed. It could be a dismissal on the merits. So the juvenile could insist on a trial at which the evidence would indicate that he or she was not delinquent, and that would have the desired result. Let's imagine the circumstance where I think it was the mother was the complaining witness, and the juvenile insists on the trial, and the mother says, I'm not going to testify, or she says something benign, like I exaggerated it, it wasn't a big deal. At that point, there'd be a finding of no delinquency, right? Right, exactly. And I think that would be on the merits, because the state would be unable to prove the elements of what the offense would be if it were committed by an adult. But I guess how is that, at the end of the day, how is that different than what actually happened here? Well, it's a distinction that the statute makes, Your Honor. It's not something that I'm insisting on. It's just the statute sets forth two distinct possibilities. One is a trial on the merits, and the other is a finding without a trial on the merits, and we've had neither here. As I said, I understand I understand the conundrum here, and I understand the contradiction, and if it were an adjudication, the ability to seal it. I just don't know if it's something that can be fixed judicially at this point. I think it's something that's probably going to have to be addressed by statute. Unless the court has any further questions, I'll rest on my brief.
Thank you. Attorney Moss, you have 7 minutes.
Thank you, Your Honor. Just a couple matters. As to whether or not, in terms of the state's interest of holding onto this charge, the 8th District looked at this and rejected the argument that for adult records, just because the state might bring charges in the future, that wasn't a basis to deny a request for sealing, and that was for adults. And so again, the same argument should be for juveniles, if not a greater ability to have these records sealed, since again, the purpose of the juvenile sealing and expungement statutes is to allow them to have these taken off the record, but for the 3 charges that are ineligible. Now, as to this part of the statute, I would say that the legislator, in looking at the finding a juvenile not to be delinquent, is really a catch-all provision and is going to encompass several different avenues where there would be a finding where the juvenile wouldn't be adjudicated, and so therefore being found not to be delinquent. Here, in looking at the records, we talked about Pepper Pike, but also there was the case from the 2nd District in regard to the court allowing a deceased person to have their records sealed, and in allowing this additional ability to have records sealed and giving more leeway, that's what should happen here. Again, this juvenile would have no ability otherwise to have her records sealed, and it would defeat the purpose of the juvenile statute to have this where she wouldn't be able to have these records sealed. For these reasons, we would ask that this court reverse the juvenile court's decision and grant AJ's request for sealing and expungement, or in the alternative, just grant her request for sealing and then allow expungement after the statutory time period. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and have a wonderful afternoon.
Thanks, Your Honor. You too.
Thank you, you too.
Take care. Good morning.
Good morning.
This is our second case on this morning's docket. This is the case of State of Ohio versus Aaron Banks. Cases number C200-395 and 396. If attorneys can please identify themselves and their readiness to proceed.
My name is Laura Peters and I represent the appellant Aaron Banks. Oh, yes, I'm ready to proceed. Sorry.
My name is Tyler Liston and I represent the appellee and I'm ready to proceed.
Good morning again. Attorney Peters, would you like to reserve time?
Yes, please. 3 minutes, Your Honor.
3 minutes. Okay. Whenever you're ready.
May it please the court, Mr. Liston. As I said, I represent the appellant Aaron Banks in this matter. First off, we have to acknowledge the one undisputed fact here, and that is that my client threw a crate in the direction of his dogs. But let's be clear, no one testified that they saw the crate hit the dogs, and there was testimony afterwards from the dog warden that the dogs appeared healthy and uninjured. So the evidence in this case simply does not support the allegation that my client cruelly beat his dogs, therefore his convictions for cruelty against companion animals should be reversed.
Now, there was evidence that there was a vocal response from the animals.
That's actually incorrect. Well, there is evidence, there was testimony. I believe Ms. Lara testified that after the crate was thrown that the dogs yelped. However, if you actually look at the video, that is actually inaccurate. The video after the crate is thrown, the dogs do not say, there's actually no more barking, yelping, screaming, whatever you want to characterize the noise as from the dogs. So after
But
that,
I thought there was testimony from the officer that the dogs were, like terrified and trying to hide and stuff like that.
they were terrified of him when he approached them. He said that the dogs were scared of him when he approached them. So that just doesn't indicate that these animals have been cruelly beaten. Maybe they're afraid of strangers. They're for all intents and purposes, they were puppies. So if they're unfamiliar with other people, then that reaction would have not necessarily been out of the ordinary. So, and his testimony is he couldn't pinpoint that there was anything wrong with these dogs. They were scared of him but he doesn't testify how they acted around my client. He doesn't say that they were scared or they cowered around my client. He just said that he looked at them, they were healthy, but based on the allegations, that's why he decided to seize the dogs.
Wasn't there also evidence from the landlord, Mr. Fetterman, that he had also, although he was there on the behalf of your client, but that he had also heard, I think, what he characterized as yelping for a matter of moments?
He characterized it as probably like 10 to 15 seconds. Definitely, I think he said definitely less than a minute that he heard some noise. Now, again, you don't know why the dogs are yelping. They could be yelping because they're playing with each other. They could, you heard, and so if you look at the video again, the video kind of corroborates there was some yelping for 20 seconds in the video, and then the dogs didn't utter a peep again. So the witnesses testified that there was yelping, screaming, and that's their characterization of what they're saying that the dogs are doing, that there was screaming. But again, none of them could actually see at that point, were actually watching and viewing what was happening with the dogs at that point in time. They heard noise, that's all they know, for like, as they testified for 10 to 15 minutes. And then several of them, Miss Laura said she went up to her fourth floor, and I think Miss Mazzola said basically essentially the same thing, that she had to go up to her fourth floor to get more of to get higher elevation to see if they could see it onto the balcony. Now, none of them actually testified that those Miss Laura, Miss LaCamp, and Miss Mazzola, none of them actually testified that they actually saw my client strike either of the dogs. Miss LaCamp said she thought that maybe he used a plastic one. There was one strike with a plastic object. But the problem testimony in this case comes actually from Mr. Cornett, who is the only one who testified that he witnessed 10 to 15 strikes on the dogs. But again, that leads us to the first assignment of error, in which he was allowed to testify via Zoom. Now, the reason why he was testifying for Zoom was because the state had failed to subpoena him. His wife was there.
Well, the reason he wasn't there is because, the court, isn't the court able to manage their own courtroom, and in doing so, make determinations under the advisements that have been provided under COVID? Well,
but you have to keep in mind the defendant's right, especially under the Ohio Constitution, to face-to-face confrontation. And that is an in-person confrontation. And there's a test. What is the public interest here? Yes, there was COVID during this time, but again, trials were being allowed to proceed. 5 other witnesses, including his wife. So if there was COVID concerns for him, his COVID concerns are not nullified because he stayed home. His wife came to court to testify. So unless she was going to quarantine from him, COVID doesn't really play here. The state used COVID as an excuse to be able to get him to testify via Zoom because it had failed to.
So you would agree that if take the wife out of the equation, but if he had said, I'm a high risk got, these extenuating circumstances and I'm high risk and I'm really afraid of coming in to testify. Would that be enough to satisfy the public interest analysis?
It would certainly be closer, Your Honor, but we had absolutely no testimony like that in this case. He didn't say he was any concern. When defense counsel asked him, what was keeping you from coming in? His answer was it work? He was even asking, was it work? Did he have responsibility? And Mr. Kernett's response was, I was unshowered and unshaven. That doesn't serve the public interest to have someone to allow someone to testify via Zoom. And you also have to make sure, not only does it have to serve the public interest, but also has to satisfy the other three components of the confrontation, and that's oath, cross-examination, and ability to appear. Now, I know the trial court prepared to take an oath, but there's absolutely no notation in the record that Mr. Kernett was placed under oath. If you look at what happened when the other witnesses, the ones who testified live in the courtroom, there's a notation, witnesses sworn, but there's no notation for Mr. Kernett. So we don't know.
If he wasn't sworn, shouldn't defense counsel have objected and said the witness hasn't been sworn?
I don't know that, the record is what it is. So, and we're going through the test and was there an oath administered? And we can't say definitively from the record here that Mr. Kernett was sworn. But we also have a problem with the ability to.
I think that's the point. We cannot say definitively that he wasn't sworn, and the record doesn't show any objections on behalf of defense counsel.
Well, so then if you take that as a toss-up because it doesn't definitively show one way, but we do have a problem for sure with the cross-examination because defense counsel wanted to cross-examine him about the video that was played, but because he was on Zoom, there didn't seem to be the ability for him to be able to play the video for Mr. Kernett to see where, and this video is actually a problem because both Ms. Laura and Mr. Kernett said that they were together and saw the crate being thrown. But within less than a minute after the crate is being thrown, you hear someone come in dropping keys, and it's a male voice saying, bringing in a dog from walking it and says, hey, are you here? This male voice is asking, are you here? So how could they have been together viewing the crate being thrown if he's coming in seconds later and asking, are you here? So we would submit that Mr. Kernett's and Ms. Laura's testimonies are simply not credible because they're contradicted by the video.
Well, I guess there's an issue of not of credibility, but I think for purposes of the confrontation clause analysis, the question is, was he not able to perceive the video during the course of his testimony? So I guess where is the best evidence in the record that he was not able to perceive the video?
Well, it just doesn't appear that defense counsel, because he was saying, is this on the video, this is what we heard. And he's like, yeah, I don't know. I don't remember. So, and defense counsel is doesn't seem to be able to have played it. I don't think that there's any notation in the record, but, again, if he was live, there would be no question that it would have been easy to call up the video and say, well, isn't this your voice coming in afterwards? Aren't you coming in from walking your dog and commenting on how it peed at the bottom of the concrete steps? So therefore, there is a problem.
Ms. Peters, my recollection of the testimony was that Mr. Kernett testified that he watched this for about 10 minutes before his wife ever arrived with her cameras. Am I correct in that, or did I misread that?
My understanding from reading of the testimony is Mr. Kernett testified that there were two separate instances that morning. So the first instance was when he witnessed, he heard noises, and so he went to the window and he looked out, and that's when he allegedly saw the dogs being struck with a stick or a rod 10 to 15 times. And then there was some break of time apparently and then the dogs began to enough, I guess, a cry and bark for a period of time that he led his wife to come upstairs, and then that's the incident where the crate was being thrown. So he separated them, that they were two separate incidents close in time that occurred that morning, is according to him. But he's the only one to testify that this earlier striking happened about 9:30. And as I said, going to the weight and the sufficiency, his testimony simply isn't credible, because the dog warden, Lieutenant Allen, didn't corroborate seeing any stick or rod there that could have been used to beat the dogs.
Attorney Peters, you have about 1 minute left.
Oh, okay. So we'll wrap it up and save my time. So we ask that you reverse. Thank you.
Okay, thank you. Good morning, Attorney Liston. Whenever you're ready.
Good morning, thank you. So first I would look to the test that should be applied when determining whether or not virtual testimony should be allowed here. I think that it was clear that the Supreme Court in Maryland v. Craig established that there were certainly some times where an in-person face-to-face wasn't necessary. They required a public interest as well as some additional indications that this was credible testimony. And then it was actually the 8th District here in Ohio that picked that up in Marcinic, and they specified, well, what we're looking for is oath, cross-examination, observation of demeanor, as well as the public interest. Here, the public interest is COVID, and I think that what.
Well, I guess my question is it the state's position that regardless of the circumstances, as long as it's during the pandemic timeframe, anyone can testify via Zoom?
So I think that what would be required is what the judge did here, and I think it was primarily the judge who indicated, it's not my intention to bring people to the courthouse, a public place, again in a continuance. Rather, we can get to testifying today with 4 individuals if we permit this to be testified via Zoom.
Well, but that's a convenience consideration, not a confrontation clause consideration.
Well, he indicates that his important public interest is COVID and not having people congregate. And to that end, and to the effect of the joint administrative order he felt he was under, the judge chose not to bring people in again. So what was being asked for by the state actually was a continuance or a continuance in progress to satisfy getting the witnesses there. And it was the judge who said, we're not going to do that. What we're going to do is have Zoom today. And he didn't consider the feelings of.
So let's say we were to look at this and say, well, maybe the trial court should not have allowed it to be done via Zoom. Then where do we go from there?
I think that it's clear here that any error that would have come about by it is entirely harmless. And the reason I say that is there are 4 neighbor witnesses who testify, all largely to the same narrative. And I think it's actually striking from their testimony how the chronology and the timeline is substantially the same, and that they each witness different parts.
Well, let me ask you this, because it sounds like each of the witnesses had kind of different obstructions that prevented a clear view. So what Ms. Peters is saying is that Mr. Cornett was the only one to witness actual physical striking of the dogs. Are there any other witnesses who testified to seeing that?
Yes, absolutely. Samantha Lakekamp herself saw what she described as the tennis ball thrower. We actually get that language from her. It was Mr. Cornett who just saw a stick-like object, but she's the one on page 64 of the transcript. She sees him raise above his head the tennis ball thrower and come down on the dog. All of them observe periods from 8 to 15 minutes, based on who's talking, of dogs screaming and whining and yelping. And I agree that all of their views were obstructed in some manner, but yet not so much as they would conflict with each other. In fact, they're all sort of telling the same narrative, that there was a crate being thrown. None of them say that crate hits them, but the torment is clear. Most of them are alerted to this situation by the screaming and the yelping.
My neighbor's dog yelps when when my neighbor doesn't let it in the house. So, I mean, I think that just yelping of a dog isn't necessarily corroborative of abuse.
Yes, I actually tend to agree, but I think what we're talking here is more than in that. This is the type of yelping and screaming that leads for people to go and see what's going on. This is, some people grab their phone and feel the need to record. I don't think that we're talking about like a typical neighborly yelping. I think that this is startling. People are being awoken from sleep. Their days are disturbed. They feel the need to investigate themselves, ultimately contacting authorities to try to get involved. As Ms. Peters points out, they don't see anything regarding a strike of the crate, and yet they still feel the need that this is beyond normal yelping. This is torment. This is panic that these dogs are feeling. And that's corroborated by the dog warden who shows up and sees exactly that. And he finds on the back porch, he remembers seeing a dog crate. He's asked if he sees the tennis ball thrower, but he says, no, at that time I wasn't looking for one. I'm trying to handle the dogs. And so to that end, if Mr. Kernut's testimony is, let's say we just view everything without it, what we see is largely the same thing. The crate is thrown, the dogs are yelping constantly. Miss Laycamp sees the dog get struck, at least she testifies once, with a plastic object. And then you have the defendant's testimony himself, who says to the dog warden, what are you supposed to do when they're, defecating everywhere? The dog warden sees that, sees the reaction of the animals, and it's then that he decides to get involved and remove the animals actually from the house. I think it was clear to the four witnesses and to the dog warden what had happened based on the different vantage points they had all had and put together. And I think that if Kernut's testimony is removed, the trial court would have reached largely the same decision. For the most part, his testimony is cumulative. And I will note that Ms. Peters now, as well as defense counsel at the time, indicates in fact, Mr. Kernut's testimony is not reliable. Well, if it is not reliable, it seems hard to say that it's the vital evidence that was relied upon to reach this decision.
But you all called it critical when you were trying to convince the judge to allow the testimony to be assumed.
Well, of course, our argument would be, that it was. I just mean to argue from the other point of view, we're trying to have our cake and eat it too. I, of course, as the state, wanted that testimony in. He saw multiple strikes. And if it gets in, now all of a sudden there's 15 strikes, and that much is clear. But without him, we still have strikes. We still have the torment of screaming and yelling dogs. I just mean to say, from a defense point of view, I'm not sure that he was the vital. He can be both non-vital and the source of a major constitutional error.
Was there anything further?
I would just like to submit on the sufficiency. I think it's mostly what I've been talking about here. So I'll submit on my brief.
All right. And I wasn't intending to, you certainly have more time if there's anything further that you wanted to argue.
Oh, no, I just checked my outline here. It looks like I'm good.
Okay, very good. Well, thank you. Attorney Peters.
Yes, Your Honor, thank you. First of all, I'd like to take issue with the prosecutor's representation that Mr. Kernut's testimony can't be, they testified, they characterized it as critical, and it is critical to establish a beating. Let's keep in mind what my client was charged with. Cruelly beating. He says that my client tormented. The definition of torment is unnecessary or unjustifiable pain or suffering that is caused by an act. What is the act? If you take away Mr. Kernut's testimony, there is no 10 to 15 strikes. There is a singular strike and a crate throw that no one can say actually hit one of the animals. And then you have the dog warden testifying that the dogs appear uninjured and healthy. So where's the unnecessary pain or unnecessary or unjustifiable pain or suffering by these animals? You don't know why. No witness testified why they were yelping or crying for what they claim was 10 to 15 minutes. Now, we can say it's unreliable because we can find where his testimony is contradicted by the video, but that doesn't mean that his testimony when he says 10 to 15 strikes isn't hurtful. But if it's not believable, it should never been, our position is he should have never been allowed to testify by Zoom, so you have to strike it out. And B, if you have to consider it, then it's unreliable. That is our position on Mr. Cornett's testimony. And also, I'd like to point out that it was the state that initiated the COVID discussion because they said Mr. Cornett hadn't received a subpoena and he's a professor at Miami. So he led the court to believe, they almost led the court to believe that Mr. Cornett was not even physically present in the city of Cincinnati when in fact he was sitting in his house in Mount Adams, unshowered and unshaven. So with that, unless there's any further questions, we would request that you reverse and discharge my client.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue you a timely decision, and have a wonderful afternoon.
Thank you.
Keep safe. Good morning.
Good morning.
Morning.
The next case that we have is State of Ohio versus Rico Mosley, case number 2, C200448. If attorneys can please identify themselves and their readiness to proceed.
Certainly. Phil Cummings for the state of Ohio, ready to proceed, Your Honors.
And Mr. Cummings, I think your mic might be set low. We can hear you, but you are somewhat low.
Okay. Let me see if I can adjust.
So there's two. It's sort of like the speaker of what you're hearing in audio, and then there's the mic of what you're transmitting.
Offhand, I'm not sure how to adjust the mic.
Okay. Well, I mean, like I said, we can hear you. It's not that we can't. As long as you keep your voice loud, you'll be fine.
I'll try to keep it as loud as I can, Your Honor.
Okay, perfect.
Good morning, Lawrence Haas for Mr. Rico Mosley. And I hear okay, but it's unfortunately a little choppy. Are you guys hearing me clear?
We are, but you are sort of,
Guess not.
You're coming in and out. So your connection is.
I'm not sure if we have a good.
Okay. An alternative is that you can, keep your video on, but you can use the phone and dial in.
I try to move offices.
Okay.
I try to move offices. Is that better?
I'll know when if you can start speaking, and then we'll see.
Okay, this is the test. Is this better?
Yeah, okay, so far it is better.
Okay.
I can hear you, yes.
Yeah.
Okay.
All
great.
righty. Okay, well, no worries. So, Attorney Cumming, would you like to reserve time?
Yes, Your Honor. I will reserve the bulk of my time, 13 minutes for rebuttal.
Okay. So whenever you're ready, you can go ahead with your 2 minutes.
Thank you, Your Honors. I think this is a very straightforward case. I think it's just a clear error of law made by the trial court. The obvious focus of the trial court's reasoning was the probable cause possessed by the detaining officer Morrell, completely ignoring the case law, which says that you look at whether a law enforcement as a whole has probable cause to justify the stop. And I think here, the first officer that testified clearly testified to observing a traffic violation. She identified it as impeding traffic. That is the probable cause that she actually claimed she relayed on to the detaining officer.
Was there any evidence that there was actually traffic to be impeded?
Yes, the patrol car that the first officer was in couldn't get past the defendant. She herself was stopped from moving.
And that kind of goes to my question, which is what was the evidence of the reliability and credibility of the information provided by the second officer?
The second officer didn't really provide any, he wasn't.
The officer who had relayed the information.
Well, she was on site. She was at the scene. She could not move down the road because the defendant's car was blocking her movement forward. She and her partner could not move past him because there were cars on either side of the street, and he was directly in the middle of the avenue talking to somebody to the side. So they couldn't get past, and that's why they were in a position to sit there and idle for 30 or 45 seconds and watch what was going on. She clearly said she was impeded. They didn't honk their horn, but you don't have to honk the horn and have traffic behind her to justify her in claiming she was impeded. She clearly provided evidence that she was impeded, going down the street. She relayed that to the officer who ultimately stopped Mr. Mosley. She had probable cause for impeding traffic. It is a citable offense. The focus on the Officer Morrell was just erroneous here. And it seems like that's the main reason, the only reason the trial court granted the motion to suppress here. It was under the misapprehension that the second officer had to have specific information, have specific facts, have the revised code statute, and actually maybe provide that to the defendant. None of that is true. None of that's supported by well-established case law. He was allowed to rely.
Well, it seems to me, though, that I think part of what was probably motivating the trial court judge was the somewhat bogus nature of the traffic violation. I mean, a car that is parked for a brief period of time, I mean, I don't think most people are going to get pulled over for that. And I think that probably was impacting his calculus.
It might have been. He might have viewed that as a pretext, and I understand your point. Although I think that all these officers working this beat were on the gang unit. They're looking for drugs and guns. They often use traffic violations as reasons to pull people over and pursue a drug investigation. So it's not unusual. It happens all the time. It's good law enforcement, actually. But you're right. That might have been in the trial judge's mind. That's very possible. As a matter of law here, though, I just think clearly the decision is clearly erroneous. I have nothing else to add unless this court has a specific question.
Attorney Haas?
Thank you very much. The first question that was asked is very telling. Was there actual PC by Officer Maloney, who is the undercover? When I had her direct examination, I asked a very clear question. Were there any cars behind you? Her response, I don't remember. There's cars parked on both sides. We were behind him. I was more concerned with what he was trying to do with the white people on the side of the street. We understand that their argument is based on Cook and Henderson, which speaks to law enforcement as a whole being able to provide PC. I'm not even sure that the undercover had PC. Let's say that she did. Let's look at how information was given to the arresting officer. This is only a little bit of crack cocaine, but it's very telling as to what is going on in these investigations. Officer, I'll call her the undercover so we don't get all of the M's mixed up, says she witnesses impeding traffic. If she communicates that to Officer Morrell, the arresting officer, and says, this is the car, this is the street, this is a traffic violation, I agree that as a whole, probable cause does exist. That is not the situation. She also has an inconsistent statement where I pose the question, did you alert Officer Morrell of the traffic violation? Her response, yes. What did you say specifically? I called for a uniformed car to pull the vehicle over for impeding traffic. Did you give him the street? Yes. Upon direct examination of the arresting officer, my first questions, good afternoon, officer. How you doing, sir? Good. At the time of pulling over Mr. Mosley, did you know what the traffic citation was? His response, I don't believe she said. I can't remember.
But how critical is it that the officer know the exact nature of the citation? Like, imagine an officer in a store that witnesses, someone stealing something, and just yells at someone down the street, like, tackle that guy, he's running, and doesn't explain, like, by the way, he stole this, it's a violation of this provision of the code.
Exactly. So that is what the State v. State v. Cook addressed. There was one officer that spotted a banged up gold truck driving down the road, swerving lanes, driving on the wrong side of the road, He then radios to another officer. Officer then pulls over and does an independent investigation, does standard field sobriety test to confirm, yes, this person is intoxicated. And it matters the crime. If there's a question of whether or not someone's been drinking and driving, it's a dangerous vehicle. It's a dangerous situation. Of course, an officer can intervene. In this instant case, Mr. Mosley was completely cooperative. Upon being pulled over, I asked Officer Burrell, arresting officer, what was his demeanor? He was calm. He gave me his license and he gave me his keys immediately. This is not that case. Of course, officers can work together in concert. I feel that's important. It's critical to safety of our population, but that is not what happened in Mr. Mosley's case. Also, the impetus here is traffic violation, and if arresting officer can begin writing a citation, I believe that would be proper. Here, he has no clue what to do when he pulls over Mr. Mosley. Usually, and he kind of gives us the playbook. The playbook of what's going on downtown and in these areas are, you have the undercovers, they witness a traffic violation, they radio into a uniform. Uniform pulls over and usually begins the traffic citation or waits. So what usually happens is the undercovers would come at the time of arrest. They would be standing around the car and they would all have a communication. What happened here? Oh, he failed to use a blinker. That didn't happen. If you listen to the body cam, Mosley client rolls down his windows and the officer has no clue what to tell him when he asks him, why are you pulling me over? I'd like to read you a little bit. He asks him, I'm not going to read the testimony. You guys can read that. He asks him, what street was I on? Gilsey, Isley, Dewey, one of those? Doesn't the individual have a right to know what street he was on committing the traffic offense? Actually, doesn't he have the right to know what the traffic violation is? It's a slippery slope if we're going to allow this type of communication to go on and not give a driver or a citizen any type of information on why he is being pulled over. I believe for this to be a good case for the state, all they had to do, it wasn't difficult. All they had to do was have the undercover officer radio in and give the arresting officer the traffic violation. What did this individual do? In Henderson, that the state cites, that's an old murder case. There is a huge murder investigation going on, and they're looking for a suspect that has been contacting the victims or families of victims by payphone. They trace a call, they trace it to a phone booth. The investigating officer sends 2 uniforms to that phone booth, check out what's going on. At the time of the arrest, the arresting officers that are sent there that aren't involved like the detective, they know what the guy's wearing, a green army jacket. They know where he's calling from, a pay booth. They then decide to corroborate that information and investigate the woman that was next to him in the phone booth and ask her questions before doing anything. That is law enforcement as a whole working together to establish probable cause. We did not have that in the instant case. I would submit on that.
Thank you.
Sure.
Attorney Cumming.
Thank you. Some quick points. The state and the officer did exactly what opposing counsel suggested we needed to do. If this court looks on page 13 of the transcript, they asked the plainclothes officer, "What did you do after you observed the behavior of Mosley?" And she says, "I radioed to the uniform patrol that we have a subject that is impeding traffic and possibly attempting to sell narcotics." Then turn to page 20, Your Honors. The same plainclothes officer is asked, "What did you do specifically again?" And she again says, "I called our uniform patrol to pull the vehicle over for impeding traffic." That's two references to the exact traffic violation that this man was pulled over for. A second thing I want to note is that the trial judge accepted that the plainclothes officer had probable cause herself. His point was that she didn't adequately relay it to Morrell, but it's implicit in his decision that she had probable cause to make this arrest or to make this citation. So if you're looking at this trial judge's opinion, implicit in his decision, probable cause was there for the infraction. I take issue with the statement that the officer had no clue what he was doing. He knew exactly what he was doing. He's engaged as part of the gang unit who are looking for drugs and guns on the streets of Cincinnati, trying to keep us safe.
Well, right. But I mean, I think this gets to the pretextual point, which is, yeah, that's what he was doing. He didn't really care about the traffic violation. All he cared about was trying the opportunity to search for drugs.
Absolutely. And I think we have to see the big picture here and see what's going on.
Well, but I think that no, I understand that. But I do think there is some issue with the concern of, if I get pulled over and I don't understand what I did, and I ask the officer, "Why are you pulling me over?" And he's just like, "Oh, you did something way down the road," and is totally vague and doesn't give any details. Like, what does that do to me as a citizen? Is then he's hauling me out of the car and then using that as a basis to look for drugs.
Well, as the court said in Cook, the case law requires no such stringent analysis. If the other officers have probable cause, that's as far as the law need go. The true slippery slope here is to getting into these types of factual analysis in a case-by-case basis, trying to figure out what the infraction was, what the code section was, how much of that was accurately relayed to the officer, how well did he relay that to the citizen. None of that's required, and it's not required for a reason. It's because it's one of these bright line rules that allows the jurisprudence to operate here and law enforcement to do its job. At the end of the day, we're just trying to protect the defendant's rights under the Fourth Amendment. When the officers as a whole have probable cause for the stop, as was demonstrated here, it's a good stop. It's a good investigation.
Attorney Cummings, I'm looking at the language coming out of Henderson, and it provides that, quote, "information supplied by officers or agencies engaged in a common investigation with an arresting officer may be used to establish probable cause for a warrantless arrest." So it says information supplied by, I think that's the operative portion. So isn't there a difference between there actually being probable cause and whether that information is supplied to the arresting officer?
Well, I
so
think
whether it exists and whether it's provided, aren't those two different things?
it did exist here and it was provided here. She testified twice that she told the officer that he was impeding traffic.
But that's not what the trial court found. Aren't we bound to the findings by the trial court?
The trial court didn't find that the plainclothes officer didn't convey it to Morrell. I think the trial court said that for somehow Morrell didn't think he knew or couldn't remember when he found out.
Well, this is what the entry says. At the time that Officer Morrell stopped the defendant, he did not know what the traffic offense was or its location. So that's a finding of fact that's made by the trial court, right?
Yes.
And even though there's evidence that might contradict that, and even though perhaps I would have found differently, there is evidence to support that. So aren't we bound to that finding of fact?
Let's assume you are. I think it still doesn't matter, because the law is that he's been told by a fellow officer to stop somebody, and as per their way of working, they know that there's a drug investigations going on. If there's a traffic violation, they will use that to pull somebody over. He just got the word from his fellow officer that we have these things, stop this car. So no, I guess the law would say, even if that fact must be accepted by you, it does not matter. He is entitled to rely upon his fellow officer's go signal. Green, stop this car. We have it. We have probable cause. You have probable cause. We as a whole have probable cause.
Can you point to, because I understand what you're saying, okay? So it's not that, I'm just trying to understand this from a case law perspective. Because again, I'm looking at this quote coming out of Henderson that talks about information supplied by, that basically checks the box, right? So what you're saying is what also checks the box is just that the knowledge is there by one of the officers, even if it's not conveyed to the other officer. So can you point me to case law that can be used to support that?
I think it's in the syllabus of State versus Cook. I think that the officers don't have to convey the extent or the full knowledge of the basis for the stop. They can just relay the information to stop, and their fellow officer is entitled to rely upon that. Quite simply, I think, yes, even if you have to accept the point that you think the trial court made as a finding of fact, it's still sufficient to allow him to rely upon his fellow officer's go signal to stop this car. The case law specifically says that. They're entitled to work as a whole. They don't need to know every fact, circumstance, basis. Oftentimes there won't be time for that. As you pointed out, Judge Bergeron, there's going to be some time when there's not going to be time to relay that kind of specificity. And so that's why the law allows fellow officers to rely upon each other.
Thank
So
you.
just the notice itself that we have it here, just pull them over. That's what I'm saying is sufficient of conveying of information. Yes. To answer your question, yes.
Thank you. Thank you. You do still have time if you'd like, if there's anything further.
Nothing from me, Your Honors, no.
Okay. All right. Well, thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a wonderful afternoon and keep safe.
Thank you very much. This was a privilege, guys. Your Honors, I wish I was there in person for my first argument in front of the Court of Appeals, but yeah, won't
maybe
forget
you
this.
will
Someday soon.
Or here, I'll give you a compliment. Maybe you'll for your fifth.
Okay. All right. Have a great day. I appreciate
All
it.
righty. Okay.
Good morning, Your Honor. Your Honor.
Morning.
Hello,
Yes. Hi. Your camera is off.
my camera is off. Is my
Yes. So
camera on?
there you go.
Thank you.
Excellent.
Can you hear me, Your Honor?
We can hear you.
Okay, I was having some trouble with my audio earlier.
Okay. Well, it looks like you resolved it.
Thank you.
All right, fantastic. So we're here on the fourth and last case scheduled for this morning, which is State of Ohio versus James Fisher. Cases number C200461463, 464, and 465. If attorneys can please identify themselves and their readiness to proceed.
David Hoffman for the appellant, James Fisher, ready to proceed.
Attorney Susan Zerfus for the State of Ohio, City of Cincinnati, ready to proceed.
Good morning. Attorney Hoffman, would you like to reserve time?
Well, 5 minutes for rebuttal, please, Your Honor.
All right, no worries, whenever you're ready.
Thank you. May it please the court, Ms. Zerfus, that I represent James Fisher. This is an appeal from 4 misdemeanor convictions, menacing by stalking, telecommunications harassment, aggravated menacing, and carrying a concealed weapon. In my brief, I raised 5 assignments of error. I intended to focus, if it's all right with the court, on the first 2 assignments of error. I'll entertain any questions the court might have on the other issues, but I'd like to just begin on the first and second assignments of error. The first assignment of error is one you don't see every day on direct appeals, and it had to do with the conflict of interest being raised right before trial by my client. He had mentioned to the trial court that his attorney had mentioned to him that the attorney had contributed to the political campaign of one of the state's witnesses. And in my brief, I claim that the trial court's inquiry into that potential conflict was not adequate to put my client's mind at ease.
Well, I mean, the court engaged in a 15-page colloquy about this issue. So it's not like the court ignored it. So,
Right.
So what are you saying? What else should the court have done?
Okay. The inquiry requirement, I mean, the trial court responded to the claim or to the issue. But in my brief, I explained that the way the court did it was to talk about it did 2 things. It talked about the timeliness of the issue, how it seemed tactically that my client had waited till the time of trial to bring this up. And the trial court made the point that if it was really important, he would have brought it up before. And I mean, it's a logical point, but it's still, I mean, objectively, it's a logical point. But when you're talking about conflicts of interest like this, it seems to me it's more of a subjective thing. It's how the client feels about things, the impression the client has. And then part of the purpose of these, of the inquiry requirement is intended to ensure defendants that they have a conflict-free representation. That's on State versus, well.
But that's ultimately an objective inquiry, not a subjective one, right?
I'm sorry, I didn't begin.
I said that's ultimately an objective inquiry, not a subjective one, right? In other words, you were talking about how it matters how the defendant feels, but ultimately the issue is there a disabling conflict that should preclude this lawyer from staying on the case?
Oh no, I think that's what that case says, the opposite. Part of the purpose of the inquiry requirement is so defendants know that they have a conflict-free representation. That's a subjective purpose.
Right, but if the defendant says, I think there's a conflict, I don't want this guy as my lawyer, but the judge analyzes the situation in the law and says there's no conflict here, like the judge's ruling prevails over that subjective feeling, right?
At the end of the day, there's no conflict. Legally, there's no conflict. That would be true. But I think it's important that defendants know that. I think when they're going into trial, they need to know that there's no conflict here. And what the trial court did was, first of all, it minimized my client's concerns by bringing up this timing issue. And then he bolstered Mr. Thompson's, I guess, professional prowess to him. But that kind of made it backfired, I think, because if Mr. Thompson thought this was important enough to mention it to my client, then bolstering his professional status would just make that concern of his of greater importance. I mean, all the trial court had to do, instead of 15 pages, it could have been 1 page. He could have just asked Mr. Thompson, is there a problem in your mind? And then Mr. Thompson, no, I can do this.
Well, let me ask you a
problem
question,
solved.
Mr. Hoffman, following up on that, wouldn't the best judge of whether there's a real conflict be the attorney himself, Mr. Thompson? And what I mean by that, if he truly felt that there was a conflict of interest, wouldn't he have made a motion to withdraw under the code of professional responsibility? Now, and given that, I do understand there's a certain obligation on the part of the trial judge, but when I read this, it seems to me that he would have been the one, the trial attorney would have been the one to withdraw if there was truly a conflict. Do you understand the question?
Oh, yeah, very much.
I mean, it happens every day. You see it every day. I mean, if there really is a conflict, the attorney will say, hey, Your Honor, I cannot adequately represent my client. I have a conflict. I'll state the conflict and then request a withdrawal. But that didn't happen in this case.
Yeah, it seems to me that from the record, this concern was raised. The client was informed, and I guess maybe the attorney left it up to the client.
Yeah, and it probably is. Thompson would have had an obligation, I think, to at least inform his client that he made a political contribution to one of the witnesses. But I expect that was in an abundance of caution, just to let the client know.
Right. But my point is I think it stirred things up enough that the client raised it in front of the judge, and then I don't think it was adequately handled. And so that's
so if we agreed with you on that, though, what would the remedy be?
I would think the remedy would have to be a new trial. I mean, it was raised before trial.
But we don't know that there in fact was conflict. I mean, you're saying that the judge didn't ask the appropriate question. So should the remedy be send it back and have the judge ask that question? And then if he gets an answer that assures the judge that there is no conflict, say everything was fine.
I don't think so, because under this case that I told you about, where the inquiry requirement, one of the purposes is to make sure the client knows there's no conflict. I think that changes the calculus during the trial. I think when a person is in jeopardy, they're in trial, they need to know that there's no conflict at that time. And I think after the fact it would not change the chemistry that he went through at the trial. I just don't think it would be a remedy on that point. So I think it would have to be a remand for a new trial. If there are no further questions, I'd like to move on to the jury waiver issue. And then this one has to do with the validity, I guess, of the waiver requirement. This is an odd situation where, I mean, all the T's were crossed, all the I's were dotted. The criminal rules were fulfilled, the statutes. You have a written waiver in the record. The colloquy was fine. Everybody said what they were supposed to say. But in this case, in the record, you've got a comment before all this happened that my client had hundreds of thousands of dollars of bond he couldn't make. He didn't know when he was going to get a jury trial. The only way he could get a trial is to waive the jury, and that's in the record. And so I analogize it to like a post-conviction case. So if you've got a guilty plea, say, and somebody wants to set aside the plea, you'd have to put in evidence outside the record to show that it's invalid, because if you just look at the record, it's airtight. I mean, there are no loopholes. Everything's fine. You have to have evidence outside the record that shows that it was involuntary. And that's the case here. It's just that it isn't outside the records. It's in the record. That's why I think I can raise this on direct appeal, and I think I've got something here. Because my client had a right to a jury trial. He's got a Sixth Amendment right to a jury trial. He couldn't get one. And
but he waived it. So I don't understand how he couldn't get one if he affirmatively waived it and, as you acknowledge, complied with all of the requirements related to waiver.
Well, I'll try it again. I mean, he did all that, but he had to do it. It wasn't voluntary, and it's obvious.
So you're saying he was under duress, effectively?
He didn't want to spend a year in jail to get a jury trial. How about, I mean, I don't know if you want to call it duress. I don't know what you'd call it, but he didn't have his right to a jury. I mean, you might say, well, we suspended jury trials and we had every right to do it, maybe. I don't know. But my client had a right to a jury trial and he didn't get one. He would have had to wait a year in jail to get a jury trial. And so, yeah, he waived it because he didn't want to sit in jail for a year. I don't know. It seems kind of obvious. It's in the record. He said that he wanted a court trial because he didn't want to wait in jail. The problem is mixing emergency services with constitutional rights. I mean, we had an emergency. It was a pandemic, and you have emergency services people running things. And you have the quote unquote stakeholders deciding that it's time to not have any more jury trials, and this is what happened. And so I think my client's right to a jury trial was violated. And yeah, the waivers are in the record, but he said he had to do it because he wanted a trial, and so he had to waive a jury to get a trial. I think it's pretty plain. It's in the record, and I think his right was violated, and because of that, his conviction should be set aside. The conviction should be reversed. The conviction's plural. So if there are no further questions, I really wasn't going to get any more technical than that. I know that the Supreme Court waives the speedy trial deadlines, but that's a different thing. I mean, that actually.
I'd like to reserve your 5 minutes.
Okay, thanks, Judge. That actually made the suspension of the jury trial unnecessary in my thinking, but under the order. So if there are no further questions, I ask the court reverse and remand for a new trial. Thank you.
All right, thank you. Attorney Surface?
Thank you. May it please the court, Mr. Hoffman. Because Mr. Hoffman has chosen to focus primarily on those 2 assignments of error, I'm going to do the same. First of all, just turning to the issue of whether a conflict existed, this is going to be determined or reviewed by this court under the abuse of discretion standard. That's going to be whether the judge acted unreasonably, unconscionably, or arbitrarily in deciding that there was no conflict in this case. And I want to just refer the court.
But Mr. Hoffman's argument is not that. It's that there was a threshold problem that the court failed to conduct the inquiry that's required under the case law.
Sure. And I think that in your determination as to whether the court did that, you have to determine whether the court if the court failed to meet that threshold as brought up by Mr. Hoffman, whether the court acted unreasonably, unconscionably, or arbitrarily. And I think in doing that, and I believe you pointed out that there were several pages, 15 pages of colloquy between the judge and Mr. Fisher on this matter.
there were, but what's lacking in that transcript is really a simple question, which is how much did you give him, and does this impact your ability to zealously represent your client? I mean, there's a world of difference between a $25 contribution and a $2,500 contribution. And if it were the latter, then you might say, well, did you volunteer on his campaign? Did you host a fundraiser or something like that? All of which could be probative of, hey, this attorney doesn't have the requisite impartiality.
And I would just ask you to refer back to page, I believe 51 in the transcript, which lays out exactly how the court approached that issue. And you're right, Your Honor, that the judge did not specifically inquire as to the depth of that contribution, but the colloquy at that time was, the defendant said, it's not the fact that I don't have any faith, Your Honor. It's the fact that when I met this gentleman, he let me know that he donated to the Fanon Rucker campaign. At which time the attorney says, that's true. I did disclose that to him. The disclosure was at that time made. And at that time, that was October 28th. This then was brought before the court on November 30th. In the period of time between October 28th, that arraignment, the first meeting at which the defendant says that this was disclosed, it wasn't an issue. The defendant says he did let me know, and he said that if I wanted to fire him, I could. It wasn't an issue to him then. It also wasn't an issue at the November 2nd pretrial. Now, on each and every one of the pretrials and hearings, this defendant actually came to court, which doesn't always happen. But in this case, there was an actual hearing in court before a judge on November 2nd, on November 9th, on November 16th, and at the trial setting on November 30th. I would note for the court that it was on November 9th that the defendant chose to waive jury. So the November 9th pretrial was the pretrial and the execution and colloquy involving the jury waiver. That period of time in which this defendant is telling the court, I just didn't want to sit in jail anymore. But then on November 30th, when the case was going to come to trial, what he did not say was, I don't want this case to come to court right now because I really want it to go to jury. But what he is saying is, well, now I'm displeased with my attorney. So now I want an additional delay. So those two actions in and of themselves, those two arguments are in conflict with each other.
Well, I understand your waiver argument, and I understand the court's focus on that on the transcript, but let's assume that's not an issue, and let's assume that he found out the day before of the political contribution. If those are the facts, did the trial court, on the record that we have, conduct an adequate inquiry?
Are you asking me if there was an adequate inquiry if the defendant had found out on November 29th of the potential conflict?
Yes.
I think that would make a difference. I think in this case, though, this court has the right to review the totality of the circumstances and act in a reasonable manner. And in this court's experience, first of all, this attorney had argued on behalf of this defendant already pretty effectively. Now, I understand that the bond was particularly high. Just because an attorney doesn't win does not mean that the attorney is acting ineffectively in any way. So this attorney was working very, very hard for this defendant. And did so again, November 2nd, November 9th, November 16th, and on November 30th. And in fact, even as counsel. And I think Judge Winkler brought up an excellent point as well, which is what's the standard that attorneys are held to when there is a conflict? We're held to a standard of disclosure under some circumstances. And sometimes it's just a matter of telling a client, hey, this is something you might be uncomfortable with. I want to tell you right now. This kind of falls in that category. Had there been what I would consider an actual conflict, which would be something like Judge Fanon Rucker and I have been close friends. I worked for him. I clerked for him. I have these.
But I think this is where the duty of inquiry comes into play. And because there was no inquiry, like we don't know what the nature of the relationship was, other than that there was a political contribution. And that could, of course, implicate a wide range of associations with the candidate, but that's where you have the duty to inquire to understand whether there's a problem.
In this case, I believe that there was substantial inquiry at the point when Judge Berkowitz indicated that, and I believe Mr. Hoffman categorized that as telling the defendant that his attorney was a good attorney. He said, I have faith in him. So he was saying that this issue was not really that big of a deal to him. He had faith in his attorney, even at the time when he was saying that he was now concerned about this contribution. And I understand the point that the court's getting to. Maybe there could have been, but I'm not entirely sure that the law requires that there be some specific additional inquiry under a circumstance like this. I think that when we rely directly on the record, which is what specifically was said, I disclosed to him that I had donated to the campaign, that the disclosure has already been made. The question then is, well, would this attorney fail to disclose a deeper relationship? And I think that once as an attorney, you have acted as an officer of the court and disclosed the conflict, you've disclosed the level of conflict that exists. And I think that that's the case here. Attorneys and judges and witnesses and police officers we always have some special relationship, interrelationships to each other. There are defense attorneys and prosecuting attorneys who have special relationships with each other. Does that rise to a level of conflict? Not always. We have the duty to disclose what our level of conflict is. And had this been a higher level of conflict, I think that it would have been incumbent upon Josh Thompson, the defense counsel, to have disclosed what that was, and as indicated by Judge Winkler earlier, to have said, this is a conflict and I need to withdraw on this case. Defense attorneys withdraw all the time on cases where there is an actual conflict. In this case, there wasn't an actual conflict. There was the concern on October 28th that needed to be addressed with the defendant. On October 28th, that defendant was not concerned. The defendant was not concerned until trial was imminent, at which point in time, the trial that he wanted was imminent because he waived his jury back on November 9th. And I do want to skip forward a little bit so that I don't lose any time on this, because I think that the jury issue requires a little bit of time as well. What's happened here is defense concedes everything about the waiver being valid. The waiver was valid in this case. It was knowingly, intelligently, and voluntarily made. And what happens with defendants all the time is that they're constantly balancing their own interests. If we're establishing some sort of rule here about how a jury trial can be delayed, and I would say that the Supreme Court has already established that in the rules, which allow us to extend the time for jury trials on the court's own motion, which is what was done here under the COVID-19 context. So the Ohio Supreme Court promulgated a rule. Hamilton County administrative judges ordered suspension of jury trials pursuant to that rule. And there's been no argument by defense counsel that, that the trial court at any point in time deviated from those administrative orders. So the Supreme Court gave the lower courts the guidelines. Anything else is a hindsight approach as to whether we should have anything like that. So just looking at that time frame, jury trials were suspended. He had the right to a jury trial. His right to a jury trial wasn't suspended. It was potentially delayed for a period of time. And at that moment, we did not know how long that was going to be delayed. As it turns out, it wasn't a significant period of time. I believe that we reinstated jury trials for a short period of time and then suspended them again and then reinstated again in February. So there was a couple of months delay there. But if we're looking at any given time, the right to a jury trial can be delayed. You request a jury trial that's supposed to start this Monday, and that jury trial in your room is along with 5 or 6 other jury trials. That court's only going to start one jury trial. The rest of those are going to be delayed for a period of time. The fact that the defendant knew about the delay just, I think, supports that the waiver itself was intelligently entered into. This is a waiver issue. This is not a denial of a jury trial issue. I think that the proper way to have gone about a denial of jury trial issue would have been for him to try to enforce his right to jury trial at the time. And if he was not given a jury trial until a later time, then perhaps file a habeas action. But in this situation, what he did was he elected on November 9th, just 12 days or 12 days after he was arraigned on the case, he waived his right to a jury trial. And it was still another 2 or 3 weeks before the case came up for bench trial. So there was adequate time for him to change his mind with regard to trial. As far as the conflict situation, I think that the court did not avoid resolution as to whether a conflict existed. The judge interacted directly with the defendant on numerous occasions with regard to this, talked to him about it. The colloquy with regard to the jury waiver was substantial and in excess of anything that we even require for a jury waiver. The forms were properly executed. The fact that he was balancing in his mind whether he would have to stay in jail for a period of time awaiting a jury trial does not rise to the level of him being denied a jury trial. if there are no other questions, just sort of addressing the sufficiency and manifest weight, which were not discussed by opposing counsel. We do believe that there was more than enough evidence in the record with regard to each of those things. And of course, it's our position that Josh Thompson was not ineffective as a result of the CHL issue, because House Bill 197 required that the expiration must have occurred between March 9th and December 1st, 2020. And there was no evidence in the record with regard to that. The standard for ineffective assistance of counsel is that it has to have fallen below an objective standard of reasonableness. And I think that it's very reasonable that trial counsel was aware of the expiration and made a tactical decision to avoid that issue of the right to extend under House Bill 197. So because those facts are not in the record, they're not something that I think are appropriate for a reversal of this matter. With regard to all of this, Your Honors, if there are no further questions, in conclusion, the trial court didn't abuse its discretion in determining that there was no conflict of interest. The defendant was not denied his right to a jury trial. He adequately waived that right. There was both sufficient evidence, and evidence was not against the manifest weight for the convictions, and trial counsel was not ineffective in any regard with regard to this case. So these convictions must be affirmed by this court, Your Honors. Thank you.
Thank you. Thank you. Attorney Hoffman.
Yeah, please, the court. Just a couple of comments. As to the conflict issue, this appeal is at the inquiry requirement stage. If this is an issue that just involved a notice, the attorney had a duty to tell his client that there was this potential conflict, and then it was up to the client to do something. My client did it. He did say, "Yeah, I'm uncomfortable." That happened right before the trial, and I'm claiming that the inquiry requirement wasn't fully met. Volume-wise, 15 pages is more than enough, but he didn't ask what should have been asked to resolve that potential conflict in my client's mind. As to the jury waiver, I'd like to use an analogy to a guilty plea where a person would waive all the rights, the colloquy would be perfect, but then he would add that he didn't do it. What would you do in a case like that? Would you say, well, all these waivers are, he signed them all, we clocked in the entry waiving his rights, and sorry, pal. You wouldn't say that. In the record, in the transcript, you'd have that comment. That would ruin the plea. The trial court would set it aside, set it for trial. And it's the same thing here. You've got the waivers, you've got all the everything that said was supposed to have been said, but you've got my client didn't want to sit in jail any longer, and he couldn't get jury trials, and so he waived his right to a jury. It was invalid, it was involuntary, and the convictions should be reversed. So if there are no further questions, I'd ask that the court would reverse and remand for a new trial. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. Have a wonderful afternoon and a great week.